Sehr geehrte Damen und Herren, dear ladies and gentlemen, es ist mir eine große Freude, Sie im Namen der Stiftung Friedliche Revolution und des Projekts Revolutionale heute Abend hier willkommen zu heißen. Sie sind heute Gast von einer Diskussionsrunde, die wir im Kontext des Internationalen Runden Tischs 2023 veranstalten, über die Frage, wie Kriegsverbrechen auch vor deutschen Gerichten vor deutsche Gerichte gebracht werden können. Das ist eine Kooperation mit der Stiftung Forum Recht, über die wir uns sehr freuen, und mindestens genauso sehr, wenn nicht noch ein kleines bisschen mehr, freuen wir uns über die tollen Gäste, die wir heute Abend hier zu Gast haben. Vielen Dank. Eine wichtige Information habe ich noch vergessen. Am Ausgang werden wir mit einer kleinen Spendenbox noch ein bisschen Geld sammeln, wer mag, für die Organisation Truth Hounds, die Sie im Laufe des Abends kennenlernen werden. Genau, damit Sie Bescheid wissen. Danke.
Ja, sehr geehrte Damen und Herren, dear ladies and gentlemen, ich möchte Sie nicht lange aufhalten, aber die Stiftung Forum Recht freut sich, dass sie diese Kooperation heute hat, und ich möchte Sie, die Gäste und das Publikum, auch im Namen der Stiftung Forum Recht zum heutigen Abend sehr herzlich begrüßen. Die Stiftung Forum Recht nimmt mit einem durchgängig partizipativen Ansatz die Fragen der Menschen zu Recht und Rechtsstaat auf und sorgt dafür, dass diese in vielfältigen Formaten adressiert werden. Dabei spielen Kooperationen eine wichtige und große Rolle für uns. So ist auch die Zusammenarbeit mit der Stiftung Friedliche Revolution für uns in Leipzig ein zentrales Anliegen, da die Stiftung Friedliche Revolution auch eine Art Demokratieerinnerung leistet, weil gesellschaftliche und systemische Veränderungen immer auch mit der Kraft von Protesten und Revolutionen zu tun haben. Der internationale runde Tisch mit dem Thema des heutigen Abends kann sicherlich nicht aktueller sein. Er berührt unmittelbar auch das Jahresthema der Stiftung, das lautet Recht und Gerechtigkeit. Die Stiftung realisiert dazu unterschiedliche Formate, Veranstaltungen und geht auf diesem Hintergrund unterschiedlichste Kooperationen ein, um spannende Perspektiven auf Recht und Rechtsstaat zu entwickeln, die zu einer weiteren Auseinandersetzung mit dem Thema anregen. Erlauben Sie mir hervorzuheben, dass ich es wichtig und gut finde, dass mit dem heutigen Abend eben auch der Krieg in der Ukraine wieder mehr öffentliches Interesse bekommt. Ich danke vor allen Dingen Herrn Dr. Stach von der Stiftung Friedliche Revolution für die konstruktive Zusammenarbeit und wünsche Ihnen allen einen interessanten Verlauf des Abends. Herzlichen Dank.
Ja, guten Abend, good evening. It's my great pleasure and honor to be back in Leipzig to serve as moderator for this panel tonight. And I would like to thank Stefan Stach and all the organizers for the invitation. We are about to discuss a very timely topic, war crime trials in German courts. The interpreters have rightly pointed to the fact that we are not discussing war crimes at German courts, but war crime trials. And our panel discussion will be concerned with potentials and obstacles of applying international criminal law. The Code of Crimes Against International Law, the Völkerstrafrechts, has been in force in Germany since 1922, and it allows war crimes, genocide, and crimes against humanity to be put on trial in German courts, even if they were committed somewhere else abroad. Trials on war crimes in Syria or the genocide in Rwanda were tried on this basis, and currently evidence is being collected for the prosecution of Russian war crimes in Ukraine. We have here tonight a very distinguished panel of expert practitioners. They all are experts, but they all are practitioners in some way, and they all are connected in one way or another to civil society. And this is a very distinguished panel, I think, to discuss this very timely issue tonight. And it's my pleasure to introduce to you tonight's panelists: Katerina Buzol, an international lawyer from the University of Kiev; then Mariana Karkutli, a Syrian lawyer and human rights activist who, among other things, observed the Koblenz trial, the first trial against state torture in Syria held in Germany. It's also my pleasure to welcome Roman Avramenko, the executive director of the Ukrainian NGO Truth Hounds, who just comes back from New York, where he received the very distinguished ELBIES. That's a prize named after the international criminal lawyer, the South African international criminal lawyer Albie Sachs, and it's been funded by the Clooney Foundation, so it's a very distinguished honor that he received in the field, and congratulations on this honor. And last but not least, it's my pleasure to welcome Dr. Somi Nicol from the Office of the Attorney General, the German General Federal Prosecutor's Office in Karlsruhe, who will talk about her practice tonight to us. My name is Alexandra Kemmer, and I'm heading the Berlin office of the Max Planck Institute for Comparative Public Law and International Law, which is based in Heidelberg, but we have also a little satellite in Berlin to do outreach, to connect with different areas of politics and bureaucracy, but also to do outreach with universities and citizens. So this concept here of the Revolutionale is also very dear to my heart. I would like, first of all, to invite the speakers to give a short statement introducing their work and their main concerns in their work. Then we will have a conversation, a round of questions and answers on the panel, and then we will have plenty of time, half an hour approximately, to have a Q&A and an exchange with you here in the audience. And I already would like to invite you to think about questions and to be not shy to engage with our panelists. First of all, I would like to invite Somi Nicol to take the floor. Dr. Somi Nicol is a judge at the district court. She studied law at the universities of Freiburg im Breisgau and Aberdeen. After joining the judicial service of the state of Baden-Württemberg in 2012, she first worked as a public prosecutor and then from 2015 as a judge. From 2018 to 2019, she was seconded to the European Court of Human Rights, and from August 2020, she worked at the permanent representation of the Federal Republic of Germany to the representation of to the Council of Europe, and was part of the implementation of Germany's presidency of the Committee of Ministers at the Council of Europe. From 2021, she again served as a judge at the Regional Court of Freiburg, and then in 2022, in July, she was seconded to the Office of the Federal Public Prosecutor General of Germany in Karlsruhe. She holds also various teaching positions and publishes regularly articles in professional journals. So you can see from this profile, and that's also why I recounted this in quite some detail, that she's a legal professional, a judge, but has also worked in different fields of what you might call the politics of international law in different organizations and roles. It's a pleasure to have you here, and you have the floor, Dr. Nicol.
Thank you very much. Well, I'm pleased to give you an idea or an overview of our daily work, the work of the Federal Prosecutor General, and of prosecuting crimes against international law. Let me start with a short historical overview, and this will give you an idea on how we work in practice. In 2002, I think you mentioned it, the Völkerstrafrechts, so the Code of Crimes Against International Law, was enacted, and at that time in 2002, there was one prosecutor working in my office at the Federal Prosecutor to deal with investigating and prosecuting core international crimes against international law. What are crimes against international law? I think you might know it. It's war crimes mainly. It's crimes against humanity, and it entails also genocide. we have the possibility to prosecute these crimes due to the principle of universal jurisdiction. I think we will speak about it later on. And this principle allows us to, you mentioned it, to prosecute these crimes even if they are committed abroad. The responsibility lies exclusively with my office, with the Office of the Federal Prosecutor General. And we started with one prosecutor, and it took some time. So in 2009, we were 3 prosecutors and a specialized unit then that would take care of investigating and prosecuting core international crimes. At the beginning, it was rather African countries that were in our focus. There was Rwanda or Eastern Congo. But with the so-called Arab Spring, we had to shift our focus more on the Middle East. And already in 2011, that was an important starting point, we initiated structural proceedings against unknown perpetrators of the Syrian regime for committing crimes against humanity. Why was this? Why structural proceedings, and what is it? Structural proceedings are against unknown perpetrators, so we have no personal proceedings, but we already collect evidence, and that was due to the witnesses, to the refugees coming to Germany. We had a lot of potential evidence, and I think we questioned over 300 witnesses in these structural proceedings alone concerning the Syrian regime, concerning unknown perpetrators of the Syrian regime. So these were the first structural proceedings concerning Syria. We had to expand then these structural proceedings to all parties to the conflict because other parties, such as opposing parties, were also committing international crimes in 2012. And in 2014, I think we will speak about this also later on, we initiated structural proceedings against unknown perpetrators of the Islamic State, also called ISIS, for having committed crimes against humanity, war crimes, and genocide, for the incidents, you might have heard of it, that happened in northern Iraq and Syria. So we had very broad structural proceedings there, also with a focus on crimes committed to the detriment of Yazidi people, of the members of the Yazidi community. And well, these structural proceedings, of course, we gained experience there, but they also brought a lot of work, I might say. So in 2018, we had 2 specialized units installed within my office, and that brought us to court proceedings. Let me just mention one example. It's the so-called Koblenz trial or Al-Khatib trial that brought us to a verdict in 2022. In January 2022, there was a former member of the Syrian intelligence service that was convicted by the higher regional court of Koblenz, the Oberlandesgericht Koblenz, for having aided in multiple times in the commission of torture and inhuman imprisonment. And this court proceeding was possible, or these court proceedings were, well, we were prepared for these court proceedings when the accused flew to Germany because we had already initiated those structural proceedings. Within these structural proceedings, we had gained a lot of evidence, and we were prepared once when the accused person flew to Germany. That was in 2018. And I think this court verdict was highly recognized also in the international community, legal community. So nowadays we have 3 units dealing with core international crimes within my office. 3 units with, I think, around 18 public prosecutors that are working on this field. The 3rd unit was set up this year due to the challenges that we face with the war in Ukraine. Now, one thing that was also, you can see that with the example of the Koblenz trial, but within our work, which is very important, is international cooperation. We are working very closely with different international partners, with international institutions such as the UN, Eurojust, and of course the ICC, the International Criminal Court. And this forms a big part, or is crucial for us. You can imagine if you have witnesses all over the world, then it can be really helpful or even necessary to cooperate and coordinate with other states, with other institutions to get interviews, witness interviews, to get the witness to the court proceedings here in Germany. We have, of course, we are collaborating, or we are working closely together with the Bundeskriminalamt, the Federal Criminal Police Office, and there we have a specialized unit which deals with these crimes against international law, the ZBKV, so the Central Unit for the Fight Against War Crimes and Other Crimes pursuant to the Code of Crimes Against International Law. They are specialized, and we are working, I think, on an everyday basis with them, and it is really helpful that they have this specialized focus on these international crimes. What forms also a very important part of our work is, of course, the cooperation with NGOs. I think we will hear about it later on. And I would like to mention also that we initiated structural proceedings concerning Ukraine in March 2022 at a very early stage. I think we heard already in Germany, we questioned over 120 witnesses. And yes, we are working also on this field very closely together with of course, our police officers, but also with the international partners. And we are trying to cooperate and coordinate also with the ICC. That's maybe just a brief overview, and thank you very much.
Yeah, thank you so much. I think we will go into some of the details later on in the Q&A. I would like now to introduce Mariana Karkutli, who is a lawyer and currently works as a legal investigator with, now I have to be careful with the name, Hukukyat, but you will give us the right pronunciation in a minute, with whom she supports the development of case files pertaining to war crimes and crimes against humanity committed in Syria. So she, in a sense, is involved in precisely the kind of proceedings that Somi Nicole described from the prosecutor's perspective. Mariana holds a BA in law and an MA in social work as a human rights profession and an MA in social and political science, and is currently a senior fellow with Humanity in Action. She's also a co-founder and a chair of the board of directors at Hukukyat and a board member with GEM. Mariana, and I would like to mention this, received her legal training at the ECCHR, the European Center for Constitutional and Human Rights in Berlin, which is a kind of avant-garde institution or NGO in Germany for strategic litigation, and maybe she will also give us a short insight into the kind of work she was trained at ECCHR. Mariana, you have the floor.
Thank you very much. Just shortly, حقوقيات means women legal practitioners in Arabic, so this is how it's pronounced. And with the ECCHR, we mainly, the legal training that I've conducted mainly focused on investigative techniques. So how do we as civil society actors who want to be engaged on investigating such crimes, documenting witness testimonies and submitting all of the information that we do to the prosecution authorities, can do it in the best practice, and how we can collect evidences. And this was mainly the training that I have conducted with them during the time where the Koblenz case was being built up, and during the time where ECCHR was providing information to the prosecution authority regarding the Koblenz trial. So that's mainly it. Shortly, before I go into the universal jurisdiction cases and the work that we do and how we do it, I want to remind you that at the time there is a case opened at the International Court of Justice that is basically related to a complaint that was submitted by both the Netherlands and Canada against the Syrian regime for violating the Convention of Torture in multiple incidents that were committed by the regime when it comes to detention, enforced disappearance, sexual and gender-based violence, and other crimes. Today the hearing is ongoing, and a lot of Syrian civil society members are there. Victims and families are there as well, hoping for a positive impact or ruling by the International Court of Justice, whereas it won't have the impact that a universal jurisdiction case would have when a ruling would come out, yet it might have an impact of, hopefully, these practices at some moment stop, because all of the work that we're doing at the moment, we're doing at the time where the Syrian regime is continuously still committing crimes against Syrians when it comes to detention and enforced disappearance, but also other kinds of crimes. So that's shortly on that as well. Just to give you a short introduction on how we work as a civil society organization at Huquqiyat. Our investigation began in 2020, June, in collaboration with the Center for Justice and Accountability. Center for Justice and Accountability is an civil society organization that is based in the US and that has conducted an investigation into Mari Colvin, an American journalist who was killed in Homs in Syria in 2013 during the siege. We focus on war crimes and crimes against humanity committed in Syria, especially during the siege and the deliberate starvation of the civilian population that happened 2013-2014 in the south of Damascus. Just a short overview, in early 2013, checkpoints limited freedom of movement in and out the south of Damascus, primarily allowing women and elderly to cross and insufficient food to enter the besieged area. This period also witnessed arbitrary arrests and enforced disappearances at different checkpoints that were upholding the siege. One of those checkpoints was called Al-Rayje checkpoint, and there was recently a case opened in Berlin, Germany, against a person who committed a war crime at this checkpoint while the siege was upheld. The case is referred to as Mofa al-D case. You can also look it up. In April 2013, the Syrian regime cut the main electricity supply to the south of Damascus, forcing reliance on costly generators that the civilians could not afford at the time. This power shortage significantly impacted local medical facilities, given the continuous casualties from snipers, bombing, and shelling. A lot of people did not manage to survive that period. In July 2013, the siege was completely sealed off. We initiated our investigation by examining crimes committed at checkpoints that upheld the siege and were controlled by armed groups functioning as the long arms of the Syrian regime at that time. Our focus included a detailed investigation of one of the checkpoints and numerous violations occurring there. We also investigated crimes committed by other armed groups during siege and in the same area. Investigating crimes committed in Syria since a decade ago, while crimes continue to be committed against civilians, at the moment as we speak, attacks against civilians in Idlib are being committed in the shadow of the attack on Gaza, in addition to the ongoing detention and enforced disappearance within regime-held areas, adds a layer of complexity to our work. Victims and survivors are rightfully reluctant to step forward. A lot of them are afraid of political persecution and of the potential arrests that they might face if they were to be deported back to Syria. A lot of them hold refugee status or subsidiary protection status, and some of them have fear of risking their families being threats who are still back in Syria. This is one of the biggest challenges that we face as a civil society organization, taking the testimonies of people. Our investigation approach is a survivor-centric approach, and it incorporates a gender-specific consideration. That means that when we look at a crime, for example, such as starvation in siege, we look at how the crime affects different members of the community because of them belonging to certain groups. For instance, women who are in starvation, who cannot breastfeed, and then as a conclusion, the child dies. This is a specific crime that affects all the community, but also affects women differently. And that's how we look at the crimes that we investigate. Our decision to focus on the deliberate starvation of the civilian population as a specific crime was strategic. That's something we've learned from the ECCHR. The crime of siege and starvation of the civilian population is underrepresented in the Syrian context, and its reoccurrence in other conflicts, such as Ukraine today and Gaza today, underscores its significance. Today, as we speak, the ongoing complete siege of the Gaza Strip, as Human Rights Watch highlighted in its recent report on the situation in Gaza, is a war crime that is being committed today. Investigating these crimes and ensuring that those responsible are held accountable is not just important, it's imperative, and not only in Syria and not only in Ukraine, all over the world. We've witnessed similar acts before in Syria, as I've just mentioned. The Syrian regime at the time launched a campaign called Kneel or Starve. And during the horrific period, a significant number of civilians tragically lost their lives due to malnutrition, injuries sustained from attacks, and the unavailability of medical facilities and the electricity cutoff. Historically, siege have been among the most prolonged and brutal operations, leading to extensive human suffering in conflict. International law does not explicitly define siege, but regulates it as the isolation of enemy through bombardment and encirclement with a focus on isolating the area. International law prohibits the intentional starvation of civilian populations and its use as a means of collective punishment. This includes a range of illness and diseases resulting from the lack of food, medicine, or other essential items. Such acts are considered and prohibited under international humanitarian law and international criminal law in both international and non-international armed conflict. Crimes like those committed in Syria during the siege of the south of Damascus, Homs, and other cities in the country, in Ukraine during the siege of Mariupol, and at the moment in Gaza, must not go unpunished. Regimes cannot continue committing the same crimes without being held accountable. It's imperative that those responsible for these crimes are brought into justice, and that's mainly what we're trying to do, or trying to contribute to what the prosecution authorities are trying to do as a civil society organization. Thank you very much.
Thank you, Mariana. As you rightly pointed out, as we speak, of course, crimes against humanity and war crimes are ongoing, and as you might have heard, the Federal General Prosecutor has also just 2 days ago opened investigations against Hamas. So it's an open-ended process, and in a way the cases we are discussing tonight are unfortunately exemplary cases, but also relate to a wider cartography of human rights violations and war crimes and crimes against humanity. I would like to introduce now Katarina Buzol. She is a Ukrainian lawyer. Katarina is a senior lecturer at the National University of Kyiv Mohila Academy and a British Academy Research Fellow, currently at the British Institute of International and Comparative Law in London. Katarina has worked on different issues concerning Russia's aggression against Ukraine, with a particular focus on the weaponization of cultural heritage, on conflict-related sexual violence, reparations, and also Ukraine's transitional justice process. Katarina has been affiliated with the Leibniz Institute for South and Southeastern European Studies in Regensburg, and I mention this because at this institute there is a group, an area-specific group or network of Eastern European, mostly Ukrainian international criminal lawyers, convened by Cindy Wittke, who has been here at the GWZO in Leipzig, just around the corner, for some years, and she has really created a hub for a connection of area-specific expertise on post-Soviet states and international law issues that is, I think, unique in Germany and also not topped by many international law institutions as my own in Heidelberg. So, Katarina, you have the floor, and we are looking forward to your presentation.
Good evening, everybody, and thank you very much for your kind introduction, Alessandra. I think that this regional focus that you have just described with respect to the Leibniz Institute in Regensburg and with respect to Cindy's work, it's very interesting because on the one hand, every armed conflict is naturally very context-specific, very rooted in usually the long historical injustices. But on the other hand, there's so many connecting threads, as we have just seen from Marian's absolutely stunning and so poignant speech. And oftentimes when we speak about closing the circle of impunity, it appears to be like a moral argument. But in fact, it's a very legal argument. And I will refer us to the recently released conference room paper of the UN Commission of Inquiry on Ukraine, released in August this year. And there, in the opening part of the report, the UN Commission of Inquiry clearly states that it's the lack of justice and the lack of accountability for Russia's war crimes in Chechnya, in Syria, and during the first phase of the Ukraine war, which I will develop on further, that the full-scale invasion has been perpetrated with such escalated atrocity and scale. So the fact that the lack of action and the fact that we don't see the connection between the armed conflicts and atrocities perpetrated against civilians across the globe, that they are connected and they should be acted upon together, it's something that is not just a moral argument, but a practical legal argument, most recently recognized by the UN Commission of Inquiry. In my presentation, I would want to focus on two principal things. First, I would like to discuss Ukraine's justice efforts and how Ukraine has been itself developing its expertise in documenting, investigating, and prosecuting conflict-related crimes, namely war crimes, crimes against humanity, and most recently genocide and incitement to genocide, since the beginning of Russia's aggression in 2014, and how that helped build up the good institutional and legal foundation with which Ukraine met the full-scale invasion. But in the second part of my presentation, I will state why those universal jurisdiction proceedings already mentioned, which are being conducted across the globe and in Germany, are an important justice avenues for Ukrainian survivors. Now, unlike Germany, as we heard, which the country that adopted in 2002 a special code to deal with international crimes, Ukraine thought that having the proper legislation on war crimes, crimes against humanity, genocide, and aggression was not really needed, because who would launch the war of aggression, who would launch atrocities in the 20th or the 21st century? That meant that with such attitude and with a very flawed criminal and criminal procedure code and very little expertise or indeed the interest of investigators, prosecutors, and I would even say domestic human rights lawyers in Ukraine, that was the environment with which we as citizens and as the country met Russia's initial aggression in 2014 when Russia occupied the Crimean Peninsula and when Russia started proxy war and occupation in eastern Ukraine. That meant that while those grave developments happened and while there was a clear lack of expertise domestically, also certain unexpected positive developments happened. First, it meant that investigators, prosecutors, and judges, and those of you who know Eastern Europe and the post-Soviet area a little bit, or do the post-Soviet studies or the Ukraine or Russia studies, you would know that these areas of government, as well as the military, are very self-contained, they're closed, they don't cooperate with the civil society, they don't really cooperate with academia. But paradoxically, it was Russia's invasion of 2014 that has catalyzed the opening of investigators and prosecutors to great professionals like Roman and his team, the human rights lawyers who did have the unique expertise in international law, who started documenting Russia's crimes in Crimea and Donbass, and who started to team up with investigators and prosecutors to build cases domestically in Ukraine and also to file the evidence about alleged crimes to the International Criminal Court in The Hague. So this, both investigative effort, but also the shift in the governance and the government and the state's cooperation with the civil society, was an important change catalyzed by the first phase of Russia's invasion of Ukraine. The second important development was that investigators, prosecutors, and judges, they also allowed the civil society essentially to train them, which was also quite atypical for Ukraine as the state. It was also important that the civil society, and most notably another prominent human rights lawyer whom you know and who I know opened your event yesterday, Alexandra Matvichuk, they catalyzed the reform of domestic criminal legislation, saying that Ukraine should finally amend its criminal code to be more legislatively fit to investigate and prosecute conflict-related crimes. And these proposed amendments are as follows. First, Ukraine should codify a full list of war crimes perpetrated in international and non-international armed conflict. Ukraine should also introduce the notion of crimes against humanity, which are widespread or systematic attacks on the civilian population pursuant to state policy, the crime that is still not existent in Ukraine's criminal legislation still nowadays. The reform should also include the provision that these core international crimes are not subject to the period of limitation, which means that if the crime is reported a decade later or 50 years later, or if a perpetrator is uncovered 50 years later, he or she would still be able to be prosecuted for this crime exactly because of the gravity of this war crime or crime against humanity or genocide. And also an important amendment was to expand the notion of conflict-related sexual violence and the gendered dimensions of international crimes, because currently Ukraine only has a provision on rape as a crime perpetrated in ordinary times, but not a rape as the form of a war crime, not to say that Ukraine does not have a full list of other forms of sexual violence, such as forced sterilization, forced abortion, gendered persecution, and other forms of conflict-related sexual violence. So with these uneven developments, on the one hand, with the increased cooperation between the state and the civil society, with the proposals to push the domestic legislation on conflict-related crimes to enhance domestic proceedings, Ukraine has met the full-scale invasion, and in a way it made the country prepared for a little bit, as far as one could be, for what we saw on the 24th of February 2022. Now, the new challenges that Ukraine has seen with a full-scale invasion are, of course, first, the number of the crimes, because previously we had a war crime unit established in 2019, but the war crime unit had a little bit than a dozen of prosecutors who dealt mostly with Crimea and with Donbass, right? And with a full-scale invasion, the whole of the country became the crime scene, which meant that the trainings of investigators and prosecutors across the country had to be catalyzed. The second is, of course, the number of the crimes. Currently, there are more than 100,000 cases that the Office of the Prosecutor General has, listing aggression, war crimes, crimes against humanity, again, are still unfortunately absent from Ukraine's legislation, which brings me to the point that the sheer number of the crimes that Ukraine has since 2022 requires strong international investigative and prosecutorial support. And this is where, of course, Ukraine hopes that Germany, countries like Germany that already have very successful record on the Syrian cases, on the cases concerning the ISIS armed group, that Germany will step in and that this structural investigation will eventually lead up to very specific arrest warrants connected to specific Russian perpetrators, because not just the survivors, oftentimes the perpetrators end up abroad, including on the territory of Germany. I wanted to finalize with a point on Ukraine's wider approach to justice, because I have been mostly speaking about the efforts in the domain of criminal justice, prosecutions, investigations, prosecutions, and convictions or acquittals. But luckily, Ukraine, being able, institutionally able, still standing as the government, as the country, as the civil society, since 2019, and now even since the full-scale invasion, Ukraine has been developing the transitional justice policy. And this is the wording that you might have heard from Colombia, from South Africa, we mentioned Albi Sachs today, from Nepal, from across the world, from the countries that came up with different measures which are not constrained just to the courts, but which are connected with truth commissions, with reforms of the judiciary and guarantees of non-repetition, and finally with reparations to individual victims of war crimes, crimes against humanity, and genocide. So the point that I'm trying to make that while the support with the universal jurisdiction proceedings is very welcomed and needed, what Ukraine as the state and with the support of international partners should do, and with the push from the civil society, is to really develop all these components of justice, especially reparations to survivors. And while there have been numerous polls, both before and after the full-scale invasion, that show that people, even those Ukrainians, including ethnic Russian and Russian-speaking Ukrainians, who live in the most shelled areas of the country, they do resist any territorial and any justice concessions in exchange for the ceasefire. So the demand for justice and for naming and shaming of Russian perpetrators in courts from survivors is very high, but in the similar vein, the demand for the holistic support through the medical, through the healthcare, through psychological support, through support with housing is equally high from survivors. So again, I will conclude by saying that I hope that both Ukraine, its civil society, and international partners for this context, and as well for the other contexts like Syrian, like Nagorno-Karabakh, like we have been hearing today, that the wider approach to justice, not only through courts, will be established and maintained. Thank you very much.
Yeah, thank you so much. And as our last speaker on the panel, I would like to give the floor to Roman Avramenko, who stepped in really on very short notice for his colleague Roman Kowal. Roman Avramenko is the executive director of Truth Hounds, and I trust that he will tell us a little bit more in a minute about his background, but also his work with Truth Hounds. Truth Hounds is a team of human rights specialists that has been working since 2014 to bring justice to victims of international crimes committed in Ukraine. And the organization documents violations of international humanitarian law, collects testimonies of victims and other evidence, and also assists with investigations of international crimes committed in the context of the conflict in Ukraine. Roman, we are very happy to have you. You have the floor.
Dankeschön, Alexandra, and guten Abend. Good evening, ladies and gentlemen, distinguished audience. In my introduction, I'd like to address the question all the panelists were already addressing. Why is it important to investigate crimes committed in Ukraine or in other conflicts here in Germany? I would say that first and foremost, and it's only mentioned Mariam and Katerina in their interventions, that the core of the meaning of international crime, saying that it is so grave that it overcomes the border of the country it was committed in, and really affects all the populations in the world, and leaving them without punishment would lead to the ultimate increase of the bloodshed, and it will turn the committing of war crimes into the regular method of warfare like it has been many centuries ago. And this will really shatter the world order that humanity has been painstakingly building since the end of the Second World War. That's why it is important not only for me as a citizen of Ukraine, not only for Mariam, for other people, for people that are suffering now in Gaza and in Israel, but also for you, for the citizens of Germany. It's one point. The second point is the people themselves who suffer from the atrocities. Many may ask, why build these cases in other countries? Despite the number of these cases can be, how many? I don't know, 2, 3, 5 cases in Germany, for instance. It's really like tiny amount in comparison to the hundreds of cases open in Ukraine, solely only in one country. I would say that justice itself lays not only in the prospect of the accountability, like putting those who's responsible behind the bars. And these universal jurisdiction cases also will unlikely, I have to admit, bring the real perpetrators to be sentenced and be put behind the bars. It's like Germany was like in the Koblenz case. But most of the cases would not lead to real sentences for those who committed crimes. But for the survivors of the crimes and for the relatives of people who were killed in the crimes, it is really important for their suffering to be recognized internationally, like that the humanity admits that they were victims of international crimes. And also, these kind of verdicts will be recognized with the broader stakeholders and countries, because all verdicts that will be issued by Ukrainian courts can be seen like biased, that Ukraine is a party of the conflict, and judges themselves can be not that fair in the judgments Putin, the responsible behind the bars. And there are already cases being prepared to be submitted to the office of Sominikol. They've been done by our NGO in partnership with several international organizations like the ECCHR that Mariam already mentioned today, and also Trial International and the Clooney Foundation for Justice. So we have prepared already 2 cases on international crimes committed in Ukraine, and we are filing them to German prosecutor office shortly. One of the cases relates to the indiscriminate shelling of Chernihiv, which is my native city. I was born in and I had lived in till the full-scale invasion started. Then I moved to capital city of Kyiv. And it involves the suffering of the use of cluster munition and suffering of multiple civilians as a result of this unlawful attack. And the second case also relates to the indiscriminate missile attack that killed many civilians in a plain day on the central square of one of Ukrainian cities. I wouldn't name it just for safety reasons. And these cases was initiated on the evidence collected by our NGO and other representatives of civil society. And this brings me to another topic, that why would NGO collect evidence in the first place? That there are investigators, there are prosecutors who's doing that. But these civil society representatives are much more flexible in their approaches. They can implement new practices and tactics, and these cases, most of the cases being brought to any country on the principle of universal jurisdiction, are being initiated actually by the NGOs who document and investigate and build case and investigate those who's responsible. And that brings me to another topic about the admissibility of evidence collected by the NGOs. In most of the criminal proceedings requires the evidence of really high standard. This standard calls behind the reasonable doubt. So the standard of collecting the evidence should be of really like strong, and they should be supported and corroborated and verified from many sources. Normally, legal actors like criminal investigators, police investigators wouldn't accept evidence collected by civil society representatives as evidence themselves. So we even stopped to call them evidence, we call them the source, the information about source of evidence. But still, all the testimony being taken by civil society, they contain the most valuable information about the development of the attack, which is crucial to assess was the attack legal or illegal, or about the appearance of the suspects or the roles in the crime. Our NGO, and we know that ECCHR and others dealing with that, and we really advocating for that, should share the methodology that are pretty much common shared among all the actors dealing with the documenting and investigation of international crimes. Several months ago, we've been to Norway, and we had talked with the unit from Norwegian police unit specializing on investigating international crimes, and we were talking about our methodology and their methodology. And they had admitted that we share the same methodology in interviewing people, corroborating evidence, collecting other stuff, preserving evidence from internet, and so on. In conclusion, I'd like to talk a little bit about people residing in Germany who fled Ukraine and who might have witnessed an international crime or suffered from it themselves, and who didn't give interview to anyone in Ukraine or here in Germany. Because despite the fact that over 100,000 cases are being already opened, I think many more to be revealed, and the source of evidence, the evidence bearers, many of them are among Ukrainian refugees residing here in Ukraine. And if you are part of this group, if you know them, I would really ask you to invite them to contact the special police unit in Bundespolice to give their testimony about what they have witnessed. If they are plain witnesses, they would contribute really to the accountability efforts, and that will help to restore justice on behalf of those who were killed or for the survivors. And if they are survivors themselves and they suffered trauma and they're suffering from trauma, this not only will bring justice closer to them, but also would allow them to start dealing with the trauma, just to talking through their experience in a detail to a very higher professionals, and that would help them to start dealing with it, not keeping inside of them. So this is my call for you, and happy to jump to a discussion. Thank you.
Yeah, thank you so much. Your last point already brought us to a reality where we have multiple investigators, in a sense, and NGOs, but also government institutions, people collecting evidence on a domestic level, but also on the international level. We have seen at the very early stages of the war in Ukraine already a number of NGOs stepping in and starting the collection of evidence on a local level, but also NGOs like Human Rights Watch or Amnesty International. Then, of course, we saw very, very quickly the General Prosecutor's Office of Ukraine taking the stage, but also connecting very efficiently with neighboring countries and international organizations. The European Commission stepped in. So like a multiplicity of actors, and then also a multiplicity of evidence, which is really unprecedented also in scale, which also might be a challenge for a federal prosecutor's office to deal with these amounts of evidence of different quality, in a sense. So maybe you would like to speak to the management of these multiplicities and how to deal with these different actors.
Well, thank you. Yes, indeed, I can just repeat what you just said. We have the central unit, as I mentioned before, at the Bundeskriminalamt, at the Federal Criminal Office. They are really specialized for dealing with such questioning witnesses, for dealing with witness hearings, and they are professional and prepared for this situation. As you just mentioned, indeed, it is. We have a certain standard, which is, of course, always with a view to our court proceedings. Our court proceedings following the Code of the Code of Procedure of Criminal Procedure, and that is it is necessary to keep in mind some guidelines or other forms that must maintained when questioning witnesses, in order that we have evidence that will be that can be taken into account by German courts. Indeed, there are, for example, there are guidelines published by the ICC, and likewise other guidelines exist to see how to deal with witnesses when they are found when they are supported by NGOs. But yes, indeed, there's a total new situation with the conflict in Ukraine. It's a lot of evidence. We have heard of the numbers. Katharina, you mentioned it. It was this is quite impressive, and of course that brings us to the situation where can we step in. One thing is that we always have to bear in mind is that we need to have perpetrators here in Germany before the German courts. That is necessary to, if you want to find someone guilty, you have the accused person must be before the German courts. That is that is a provision, and that makes that brings us to the point that we have. Yes, indeed, we have universal jurisdiction, but we will. It should only be activated where practically feasible. So we have to. Either we have to always have to have a link to Germany. So it can be that there's a German perpetrator or a German victim, but it can be also that there's court proceedings in Germany that are likely to be held in the foreseeable future. So if we have these requirements met, if these requirements are met, then the universal jurisdiction is activated, always with a view to have personal investigations, personal prosecution before German courts in the end. Now, with the evidence that you just mentioned, let me just highlight one more thing. We are closely cooperating with all international parties, but we especially, I think, we should highlight the role and the importance of the ICC. So we are trying to support the ICC by replying to requests for legal assistance, by coordinating with them closely. And I think the work of the International Criminal Court is crucial, especially bearing in mind what the possibilities of the ICC are. Just a brief hint to the ICC, but yes, I hope I could have given you a short idea of how and when we can only activate universal jurisdiction.
Can I add a bit about the
Sure.
importance of coordination? It's really important because there are many domestic actors. First and foremost, prosecutors and investigators, and the vast majority of the cases for crimes committed in Ukraine would be investigated and prosecuted by Ukrainian authorities, official authorities. But there are also, for instance, two coalitions of NGOs assembled around the idea of accountability. One is Ukraine 5M coalition, and the other is Tribunal for Putin coalition. They both aim for the accountability for international crimes. There are international experts being sent to Ukraine to reinforce domestic efforts. There are a team of the ICC analysts and investigators in Ukraine. There are international NGOs, like those I already mentioned, but also the Human Rights Watch, Amnesty International. There are interstate bodies like UN Commission of Inquiry, like the UN Human Rights Monitoring Mission. The OSCE has relaunched its kind of monitoring activities, and they are not really coordinated right now. They sometimes they work in parallel, and in some cases it leads to multiple interviewing of the same people by different groups and actors. And that is something that our NGO and me personally is putting like a lot of efforts to coordinate between all the actors involved in this process. And we've got some already like positive examples. For instance, so this all spins around the evidence analysis database. So where all the evidence collected by whatever actors are being put into, and then taken out if they are needed by any kind of other actors. For instance, the UN Commission of Inquiry, they also conduct field visits like we do. Truth hounds, essentially, like a field workers who has been dealing with the field work, investigating, I beg your pardon, interviewing, collecting evidence on the ground, filming the destruction, assessing the impact craters, stuff like that for 9 years already. And we've got like many thousands of testimonies already taken and that are in our database. And when the UN Commission of Inquiry sending their field mission, for instance, to Kherson region, they can look up into our database and select the testimonies that are of their particular interest, and they wouldn't need to re-interview them, but just to follow up on the basis of the evidence collected by us. And the same goes with these coalitions. One NGO traveling to some settlement, they collect some evidence, they interview several people, they haven't identified another incident in the other settlement, but their lack of resources, the lack of time, they can't really document it. They coming back, they share the information, and the other NGO is doing the follow-up mission, and they not knocking at the same door, not interviewing the same people, but they doing the follow-up. That's why it's really important to have the NGO who are engaged in this kind of activities for almost a decade to be more broadly included in these coordination efforts. We lucky that we were invited several times to the pre-meeting of the Genocide Network, to the Eurojust, because Eurojust is basically the only state actors can be inside the Eurojust, and there are 5 international NGOs are also in it. So they gather behind the closed doors, and they coordinate the investigations, sharing the evidence, stuff like that. NGOs like us, they can contribute to this process as well, because we know the context. We've been in this business, let's say, for 9 years already. And we possess large amount of valuable evidence as well.
So is there not also, considering these high level of activity, a risk that you create high expectations as to individual justice? I mean, Somi already pointed to the fact that from her perspective, from the perspective of the Federal Prosecutor's Office in Germany, there should be a kind of realistic prospect that a case can be tried in the foreseeable future in a German court, and it shouldn't be like an abstract exercise. And that brings us to the basic tension of international criminal law that we always see, that there's on one hand side the idea that there should be individual justice. On the other hand side, it's also very clear that these cases are to some extent symbolic, or maybe aiming not so much on individual justice or reparation, but also have an aim which lies in a kind of transitional process which creates stability in a region, or even establishes facts that help to memorize or remember a conflict situation, and therefore to lead to reconciliation. So how do you deal with these different objectives in a way. And I would like also to bring in the ICC was already mentioned, and from a German point of view, the German government's strategy is kind of twofold. On the one hand side, they are striving towards a reform of the ICC, which enables also to try cases originating in Ukraine, but then also there's the aim to establish a specialized court in Ukraine, which has hybrid elements, which means bringing in some international elements, judges from abroad, but also being based within the Ukrainian judicial system. So I would be interested how these models in a way relate to your work on the ground, Katharina and Roman, and how they also relate to your understanding of what you are aiming at when you are working towards international criminal justice.
Thank you very much. These are very pertinent and big questions. I think actually the civil society have been doing a good job in Ukraine managing usually the expectations of survivors, saying that these cases are going to take long, and this is how we prepare the universal jurisdiction cases as well, including those that Roman has mentioned. So we do say straight away to the survivors that these cases usually take a long time, and they say, yes, we are ready, we are really, they understand that the validity of the pronouncement of a German court will be different because of certain concerns that Roman has mentioned to the pronouncement by a Ukrainian court, for instance, right? Because that should be more trust with respect to impartiality. So even this symbolic judgment, even not necessarily in their own case, but generally the pronouncement by a foreign court or by the ICC for that reason on the issues of Russia's war crimes in Ukraine are important to survivors, to the point that I could tell you that when 2 arrest warrants were issued by the ICC with respect to Mr. President Vladimir Putin and Maria Lvova-Belova in spring this year, survivors texted me with congratulations. Not survivors who were affected by children's deportations, because the arrest warrants concern children's deportations, survivors of conflict-related sexual violence, but for them, even the symbolism of an arrest warrant against Putin was already important. I actually would be a bit more critical towards the Ukraine as the state, the way the public communication has been conducted, with the statements that we will go after every single crime and we will find every perpetrator. I guess there a little bit of subtlety is actually needed. So at least in my experience, the civil society manages the expectations of survivors a little bit better than the government does. I also wanted to add a little bit on the documentation and over-documentation. I think it's great that with the full-scale invasion, many NGOs have really boiled down their specialization. We have a number of NGOs that deal exclusively with crimes affecting cultural heritage or exclusively with the crimes affecting children, because they understand that what they would like to produce is the quality of submission either to a Ukrainian prosecutor or a foreign prosecutor in Germany or the ICC. So they have done this analysis and narrow specialization. The problem with over-documentation, I think, is lingering more with the journalists and academics who go to the recently deoccupied areas and do this over-interviewing. They usually do it for very good reasons, for the desire to cover the story, to tell the story to the broader audience. But there is this gap between the journalists and academics not really synchronizing their interviewing with the investigators, or at least with human rights and the civil society.
Thank you. Before opening up, I would like to ask you, Mariana, one feature of international criminal law in recent years has been the emergence of the prosecution of gender-oriented violence. How does that play out in the cases you have been working at?
I think Katharina mentioned this very clearly earlier, and that's basically for a long time, even on an international level, the crimes that are committed within a gendered lens were always looked at as sexual-related crimes, but never from a wider perspective. In Syria, for a long time, women had no no equal rights to men. They had less rights. Sharia and the former French law both constitute the Syrian law at the moment. Mostly Sharia governs what the personal status law is that governs us as women. So for a long period, even before the war, we had no equal rights to men. And then when a war situation happens, and for example, a man in the family is detained, because according to the law, me as a mother, I cannot register my child under my name, the child goes undocumented. This is one of the situations that we've been seeing as we were conducting the investigations, which leaves women in a very vulnerable situation. That applies to all the other example that I gave when it comes to starvation and siege, but all that also applies to women victims and survivors who manage to go out of detention, want to speak about the experience that they've had, but there is a lot of stigma behind them even speaking about what happened to them from the society itself, an embedded stigma even before the war that does not allow them to speak up. Or if they spoke up, they would be even attacked from their families or their communities around. The Syrian civil society have been doing a lot of work in the recent years around the stigma and around the change in laws that are applied on women inside the country after seeing the result of, in a war situation, how these regulations and laws affect the lives of women. Today we're talking about women who are living in Idlib, where the same laws are applied on them in the northwest Syria, the same Syrian laws, and they cannot have sometimes first aid for their children because the children are not registered, so they do not exist in the eyes of the world. So there is a lot of work being done, there is a lot of work going towards changing the situation, but that's how it plays in our investigations. We basically realize, how the crimes were committed affected women differently, B, how a lot of women survivors are reluctant to come forward and speak up about their experiences, and C, the current injustices that they live that does not allow them for a space to go and speak about crimes that were committed against them years ago. So.
Thank you. I'm sure I would like to open up. We have a few more minutes, and I'm sure there are some questions. I would like to collect 3 questions and then give it back to the panel. The questions can also be, Sie können die Frage auch auf Deutsch stellen. Ich übersetze es dann für die Panelisten. Sie können auch gerne Ihren Namen sagen, wenn Sie möchten.
Hi, I'm Paula, and thank you so much for your input. As a person who's really impressed by international criminal law, I would also like to, at the same time, ask you a question about a common criticism of international criminal law. Because I would be really interested to hear what you think. So this is about the criticism that international criminal law is very much politically influenced and therefore also biased. I mean, this is a common problem with establishing jurisdiction for the International Criminal Court. To my knowledge so far, there have only been African persons prosecuted charged by the International Criminal Court. And for example, it would be impossible to bring ISIS to the International Criminal Court even because for example, the US would be blocking any jurisdiction over Iraq through the lane of the Security Council. My question would be, how do you deal with that? Do you feel like it is different in a national prosecution? Is that maybe the solution because you have universal jurisdiction, or is it still political in the core, and is that simply a discrepancy between the claim of the goal of universal jurisdiction and the reality that you just live with? Thank you.
Thank you. I see one more question here, and it's very dark from here, so you need to have it here. Yeah.
Ja, vielen Dank für die interessanten Vorträge. Ich habe ein Problem mit dem Begriff Kriegsverbrechen. Ich glaube, wir sind uns alle einig, dass Krieg kein rechtlicher ziviler Zustand ist und dass im Krieg Verbrechen begangen werden von allen Kriegsparteien. Also es werden Menschen getötet, Menschen verletzt, Sachen beschädigt. Und von daher würde ich eher dafür plädieren, die ganze Energie darauf zu setzen, den Krieg zu beenden und Vermittlungslösungen zu erreichen. Ich denke, dass es sehr schwierig ist, eben alle kriegsführenden Parteien gerichtlich zu belangen. Das würde die Gerichte überlasten und die würden gar nicht der Sache Herr werden. Also ich finde, ich habe, wie gesagt, ein Problem mit diesem Begriff Kriegsverbrechen, würde eher davon sprechen, dass Krieg ein Verbrechen ist.
Okay, so I'll try to translate the question. The speaker has a problem with the notion or the concept of war crimes, because as he says, war is not a legal situation, a legally regulated situation, and there are always crimes in a war situation, and he would rather plead for negotiations and mediation to come to a peaceful solution. Also, pragmatically, it would be very difficult to try war crimes. So why not go for peace negotiations instead of spending energy or investing energy in war crimes investigations? So we have one third question. Eine dritte Frage.
Hi, my name is Dolkun Issa. I'm the Uyghur origin. So, is a crime against humanity and genocide is committed by the country? Most of the time maybe wartime, but sometimes not wartime. Some government and they commit genocide. For example, China today commit genocide and crime against humanity. Uyghur and other Turkic Muslim in China since 2017. But China is not member ICC. And ICG is China is a veto right in the Security Council. So it is a difficult situation, of course, and also not war in China, but it is a reality. Today, more than 3 million people in the concentration camp, rape and also forced sterilization, and around 1 million Uyghur and the Tibetan children separate from family, like in the Putins. This is UN experts report is have evidence, and one of the People's Tribunal established by Jeffrey Nice, who is the former prosecutor of ICC on Yugoslavia. He set up the one People's Tribunal, then collected 18 months huge evidence and the 3 official hearings. Then is a verdict 2021. September 9, saying Chinese government commit against Uyghurs genocide, a crime against humanity. So, and my question is, and according to German code, in the German code or the universal jurisdiction, is a possibility and can investigate and Chinese government or Xi Jinping's commits genocide, a crime against humanity.
Okay, thank you. So we have 3 questions. I would just ask the panelists to pick up on whatever question they wish, and maybe Somi, you would like to start.
Well, thank you. I think concerning the first question, I fully understood what you said, and with the bias concerning national prosecution, where I can speak, is that I mentioned it. We are investigating and prosecuting against all parties in the Syrian conflict, and I think we do this in an objective and in a manner that is according to the rule of law. And also concerning Ukraine, I didn't mention the whole title, but the title of the structural proceedings against unknown perpetrators of all parties to the war in Ukraine shows that I think we, or the Prosecutor General, is able to investigate, to prosecute in an impartial manner. maybe touching, making a little hint on, I will not go deeper into this, but just mentioning it again, we have the principle of universal jurisdiction, I mentioned it before, but of course we have to have the link to Germany, we have to have either German perpetrators or German victims, or we have to have, and this is according to our code or our StPO, Strafprozessordnung, we have to have court proceedings to be held likely in Germany, so we have to have a perpetrator here in Germany. Maybe just on this.
Okay, thank you.
Just shortly, when I was doing my studies, also during the time of the legal training, I was interested in this particular question. There is a very interesting author called Maximo Langa, who spoke prolongedly on the criticism towards the universal jurisdiction and how it works in different countries. And I think that would be an interesting read. It was a very interesting read for me at the time. Just
Roman?
Thank you. I will address two questions. First question from Paula. Thank you for the question. I would say that ICL is not really biased, but maybe underdeveloped in a way. Especially, for instance, there's pretty much hard to investigate crimes against environment, like war crimes, because there are so many limitations in this clause. And also, for instance, when we really looking deeply in the crime of genocide, trying to prove this, the war of Russia against Ukraine is really genocidal, but the law itself is being comprised in a way. It leaves really few avenues to apply for the current situation, despite the fact that it's a pure genocidal war, and I will address with this to the question about why wouldn't just negotiate and stop the atrocities. Indeed, the concept of war crimes in the whole idea of international humanitarian law starts to be applicable only when the conflict is already started, and it should prevent the civilians from suffering, and the prisoners of war from being tortured and executed, and from the protected objects like civilian property from being destroyed. But on the matter of negotiations, where to negotiate to? These recent outbursts of the hostilities around Gaza did raise many similarities and questions from Ukrainian Twitter society. They started asking, why wouldn't Israel start negotiating with the Hamas, saying like, all right, let's leave them all these kibbutz they have seized, and let's start negotiate with them, not to stop hostilities and to prevent the bloodshed and for the civilians, innocent civilians from being killed. And that is something that we have also in Ukraine. We want to live, our neighbors want to see us dead. There's not much room for compromise.
But can I also say something to that? Apart from criminal justice, there is also other concepts of justice, or forms. There is restorative justice, and there is a transformative justice. And there are a lot of forms that we all aspire to, because I agree with you. The point, at least philosophically, to me, the point is not to put people behind bars. And things will not be solved when people are behind bars. The problem is how to build a world in which these crimes are never committed again, and people are not being harmed again. And that's, I think, where at the moment the tool that we have is a criminal justice tool, but it's not the tool that I think would build countries after, hopefully, wars are ended either in Syria or Ukraine or other countries.
Well, on the point of bias of international criminal law, it's very interesting because you mentioned that initially the majority of the accused were the people from the African states, people black and non-white people. And it's interesting that that was considered to be biased. Then when there appeared the Georgian case, the Georgian investigation, and then the arrest warrants and the first enhanced attention to Ukraine, there was another accusation of bias, although we could say that they're finally the white people and the leaders from, well, the certain version of the global north there in the case of Russia. So I would just say that there is, you know, there are different ways to interpret this bias, but what we should do, we should see what light we could bring there. And for instance, the whole discussion about the alleged selectivity with respect to Ukraine has actually really catalyzed also the discussion about the reform of the International Criminal Court. Alexandra slightly mentioned the issue of the special tribunal to try Putin's aggression, but the parallel proposal, including done by German Professor Dr. Klaus Kress, who is the special advisor of the ICC prosecutor on the crime of aggression, is to do the parallel reform of the court to make sure that it's less biased, and then in the future situations there would be the possibility to investigate and prosecute the crime of aggression even if such states like Russia are implicated. So what I'm just trying to say is that even in such a highly complicated situations, there can be a room for solution. And there's also, of course, the room for more correct formulation of support. I'll bring the example of Canada that included its financing to the International Criminal Court by saying that these funds should go to support survivors of conflict-related violence, adding from Ukraine. And of course, politically, it was a very wrong additional formulation. What they should have done was just to say that this additional donation to the ICC would go to support victims of conflict-related sexual violence from across the situations that the ICC is dealing with. So this is also the question of correct communication. But I think the example with the crime of aggression and how Russia's aggression has really catalyzed the discussion about the Rome Statutes reform on aggression is an example that there can be light brought there. And with respect to negotiations, whatever occupied territory from Russia we take over, we uncover immense instances of war crimes, crimes against humanity, and possibly genocide perpetrated there. So the argument, not just the legal, but the human argument, is that if we negotiate and cede certain territories to Russia, there is just a factual evidence that Russia will continue those repressions there, even if those territories are under Russia's control. And of course, there's also the wider argument that there is a firmly established principle of international law about territorial integrity and recognized borders, recognized including by states like Russia. And ceding it in the case of Ukraine would mean that these principles are ceded or could be ceded in many other cases as well. And I would just also recommend to you the recent report by Chatham House called How to End Russia's War on Ukraine. And it actually has a very interesting approach because it addresses fallacies. It addresses the fallacy, like, for instance, Ukraine should cede Crimea and other demanded territories to Russia, and the report explains why this is a wrong approach. So for more in-depth analysis, I would encourage you to look at this report. Thank you.
Thank you so much. I'm sure there are many more questions, but we have to conclude here, also to give the audience a chance to go on to the next event of the Revolutionale at the Kupfersaal. I would like to thank the speakers. This has been such a rich discussion and such a profound dialogue, I would say, and thank you. Well, I think we didn't answer your question, but I'm sure you might get in touch bilaterally with the speakers after the event, and maybe there will be an answer to your question. So I hope we can ask you for your understanding that we didn't get through with your question now. I would like to thank the panel for sharing your expertise, but also your vision and your reflexive thoughtfulness towards the kind of practice you do in your different roles. This has been really a rich evening, and I learned a lot, and I think so did the audience. I would also like to thank the audience for your questions, and I wish you a good evening and also many more learning experiences during this Revolutionale. Thank you so much.